Well, good afternoon, everyone, and glad you could join us for this latest Family Law Hub webinar. I'm David Chaplin, publisher of the Family Law Hub, and I'm acting as moderator for this session, as ever. I'm joined today from London by Mena Ruparel, who is going to take you on a tour of the new Law Society Family Law Protocol. Mena was one of the authors of the new edition and is a well-known family law trainer. I'm sure many of you have been trained by her before. Before we get started, just a few administrative points. Firstly, you can download the slides as a separate handout using the handout feature in your GoToWebinar software. It's on the right there. Secondly, we encourage you to send in any questions you might have using the chat panel, also in the GoToWebinar software. I will put them to Mena as we go along at an appropriate point. Thirdly, the session is being recorded and will be available to play on demand for paid-up members of the Hub. And that should be done early next week. We'll send you links when it's ready. And finally, you can claim an hour of CPD for listening in today, whether or not you are a Hub member. So that's a freebie for you. So that's the administrative points over. I will now pass you over to Mena to take us through the new Family Law Protocol. Over to you, Mena.
Thank you very much, David. Hello to everybody, and hopefully there are some people there who may be sitting with a copy of the protocol in front of them. Certainly most people will have the last edition of the protocol, but it's really surprising that it's been 5 years since the last protocol was written, and of course in the last 5 years things have changed enormously, and they are continuing to change, so it's really important that the protocol was up to date. And as you said in the introduction, I'm one of the authors, but really it's been a group effort. The Law Society Family Law Committee, of which I am a member, have been working on this project for a year. We've been helped by lots of people from Resolution and other people who've had a huge input into this. So lots of very experienced family lawyers have put their heads together to make the protocol, which is, for what you're getting, it's enormous value because it's a great book. It covers lots of different topics and there's lots of cross-referencing. You can buy this version of the protocol on as an online edition, and so you get then the benefits of the links to the other resources. And it's really important, of course, that there was a new protocol, because since the LASPO Act, really funding has been impacted and the way that we deal with things has been impacted, and it's really important for there to be, something all in one place where people can have a look and say, if they need to check anything, this is the place to come and check it, for starters. So it's really a valuable tool to have. Who's going to benefit from it? And lots of people will say, well, I'm an experienced family lawyer, why do I need to have a look at the protocol? I think all practitioners would benefit from having this. Particularly, I would say, people who are new to the area, so perhaps paralegals and trainees could do with reading it from cover to cover, really. Anyone who's about to come into family law, it's such a good grounding for people who have never looked at family law. There's so much information in here that it would be really, really useful. Maybe those returning to practice, having not done family law for a while, maybe on maternity leave, maybe having given up the law and coming back to it, and of course we see that quite often. And specialists who specialise in one area of family law, so maybe if you specialise in public law or private law children and you don't really do other areas, it's a good way of cross-referencing and saying, well, I have this book that I can have a look at other sections of family law. So if somebody comes in and they've got a crossover issue, it's a really good place to have a look, and it's up to date as of a month ago, so it's as up to date as you could possibly be with a sort of print book with an online version, and we're hoping that we'll be able to update that as quickly as possible. So it's a really good overview of best practice guidance, which it has been since the first edition came out many years ago. There's a foreword, as there always is, from the President of the Family Division. It's always good to get an endorsement, and he says the protocol distills the important elements of practice and procedure clear and helpful guidance to family practitioners. Adherence to part 1, and we'll have a look at each part in turn, will assist them in achieving the overriding objective to enable the courts to deal with cases justly. So an endorsement from the President as to the importance of the protocol. And I think everybody who practices family law has heard of the protocol. It's been a long time since the last one, so it is, as I say, useful to have a new one to refer to. The main protocol that the President was just referring to in the foreword is available without charge on the Law Society website, and I've put the link there. David, I imagine that you can distribute that link, because it won't be easy to access on one of the Family Law Hub updates, so that people can just click on that.
Actually, what I'll do, Mena, I'll send that out to everybody after the event when we send the links to the recorded versions and things like that. So I can do that at the same time.
That's really helpful. Thanks very much, David. Of course, if people download the handout that they've got, they'll have access to it immediately. But you can easily click on that link, open the main protocol, which is a few pages, but that's the bedrock. That's the foundation of the book, really, and it's general guidance to all practitioners, and it does of course cross-reference to the resolution codes of practice and their guides to good practice. So this isn't separate to resolution, this is a joint effort. It is published by the Law Society, but we are looking at a holistic approach to family law to make sure that resolution and the Law Society work together, and that people who follow resolution and the Law Society are all doing the same thing. So it's best practice guidance, and it doesn't contradict resolution, so it's just cross-referencing. And it sets out really useful things. And what I was saying in the introduction about paralegals and trainees, for example, this main protocol, which is free on the family law, on the family website, would be really useful as an introduction to somebody who has never looked at family law. And it's also a useful reminder to those of us who've done family law. For example, I've 15 years post-qualified, so I've been doing it a long time. It's really useful to have a look at it and say, oh, actually there's a couple of things that have changed. Or perhaps if you haven't done legal aid work in a while and you're not really up to speed as to what legal aid is available for, it's useful to have a review of that. And it refers to the dispute resolution processes, and of course it's the dispute resolution week this week, so it's important to note that there are new processes that were introduced since the last protocol was published. Importantly, arbitration for financial cases, and of course it's possible that arbitration for private children work is on the very near horizon. So it's constantly evolving. Family law changes all the time, and the main protocol really sets the scene. Moving on then, what I'm going to do, David, is I'm just going to look chapter by chapter really at the things that I think are highlighted or changed in the protocol to give people a really good idea of what's contained in the book, and that means that they can go away and buy it or have a look at it if they want to, and decide if it's a tool that they really need in their toolbox. The main protocol, as I said, is the free version, and it covers lots of things. For example, SRA issues, which are important, compliance matters, dealing with vulnerable clients, and of course that's becoming something that we're looking at more and more in family law work, looking at administrative client care issues and how to deal with the ever-increasing litigants in Person and Mackenzie Friends with cross-referencing to the relevant guidance. And looking at good practice, and this is something that comes up quite often when you are in practice, which is the giving of notice when you're about to issue proceedings, and the best practice guidance on that, which of course is repeated as it has been since the first version of the protocol, that it's really important that the parties, where appropriate, to give notice of the intention to issue proceedings. So that's the first part. The second part, then, we go straight in NCDR, which is of course non-court dispute resolution, as it was rebranded a couple of years ago. And this section is really important because dispute resolution becomes ever more important for practicing solicitors, and this short paragraph, which is nearly 20 pages, really sets out everything that a family lawyer would need to know to start off with in terms of dispute resolution. It touches on arbitration as a non-court dispute resolution process. Of course, we haven't been able to incorporate the President's guidance, which was released yesterday, and I saw on my Family Law Hub email you distributed yesterday, I think, David. I don't know whether you continue to distribute that as we go forward, but that's really important, is the guidance that was given by the President yesterday.
It's on the hub and it's freely available there. So it's listed under practice note on the Family Law Hub. So it is there, and it includes the guidance and of course some orders as well. Yeah.
Yeah, that's right, the draft orders. So we haven't been able to include that in the protocol, but we have included the introduction of arbitration. I'm an arbitrator myself, and arbitration, I think from last year, I think the numbers have doubled since last year. So there is increasing use of arbitration in financial cases. In this chapter, we haven't touched on the possibility that arbitration is going to be made available for private children cases in the near future, and I think courses are going to start to run from next year to deal with that. But of course, in the next version of the protocol, that's something that you can look out for, because of course arbitration is an important tool. It's received judicial approval, and of course the practice note from yesterday gives even more judicial approval, if that were needed, to the availability and use of arbitration. It can be cost effective and of course is very flexible for parties to use. And as the family court changes, I think practitioners need to really look to expanding the change in their practice to suit the change in the court system. The chapter in the protocol also covers mediation, as you would expect, in quite a lot of detail. So for those people who are new to the area or are returning to practice, the relevant information about mediation and MIAMs, really important to look at screening. And of course, if you're not a mediator yourself, then the screening process is something that you don't get involved in. So there's good information about the screening process and information that I think practitioners would find really useful about choosing a mediator, how you would go about choosing the mediator, what you need to look out for. And I think that the last statistics I heard post-LASPO Act was that 50% of mediation practices had gone out of practice as a result of the LASPO Act changes. So it's really important that we keep on top of who the mediators are in the area, and as mediation changes, the way that we use mediation will change. And the chapter looks at all the different mediation models, and many family practitioners are accustomed to referring to a mediator for the MIAM appointment, and perhaps don't know that much about the different mediation models. But the part 2 looks at co-mediation, it looks at anchor mediation, looks at mediating with legal representation, which is something that not many solicitors are invited to participate in, and also looks at shuttle mediation and caucusing. So lots of different models there, not just this is mediation, you should use it, lots of important information, and of course looking at child inclusive mediation, which is a growth area. Of course, we look at collaborative law in this chapter, as you would expect, as an NCDR process, and how that can be used and what the benefits of using collaborative practice could be. So this chapter is really very important and very up to date, and it looks at all the different routes into non-court dispute resolution, cross-references to lots of other areas that we could be looking at, and for somebody who's interested, cross-references to other important documents. And so in Dispute Resolution Week, it's important that we recognise the importance of this chapter and all the information that's contained therein. As we go through the protocol then, we start to touch on areas that weren't in existence at the time that the last protocol was published. And so part 3 is and was domestic abuse, but now we've coupled together honour-based violence in part 3. And we look at both in this chapter, and of course there is a huge amount of crossover between the two, and I would say that honour-based violence is something that many practitioners will be aware of peripherally, but probably haven't had the opportunity to deal with any cases because of the nature of them. But what this chapter really takes the practitioner through is making sure that you recognise the domestic abuse, that you recognise the honour-based violence, and there are in here some really, really helpful screening questions that you can use, because of course what you're not going to necessarily say, or what's not going to produce the right results, is, are you suffering from domestic abuse? And there are lots of different screening questions that you can ask, and of course it gives definitions where there's not a specific definition for domestic abuse. It gives examples of things that are included within that category. Honour-based violence, as I said, very new, very niche work, and it may be that practitioners really want to have a look at this and say, right, these screening questions are really useful, I'm going to print those out, I'm going to keep them in my room and make sure that I'm aware of these, because they are questions or they are screening issues that perhaps you might be aware of, but if somebody came into your office, you might not necessarily be able to find them in the bunch of information that you keep in your office. So something that you would keep at the forefront are these screening questions. So there's 3 or 4 pages about screening questions, and then cross-referencing to various other websites for further information, making the practitioner aware that of course criminal proceedings can be taken as a result of breach, and the priority here is to keep the client safe, which of course those practitioners who deal with domestic abuse are perfectly aware of. There is also a section here for acting for the respondent, and of course in the recent years respondents have not been entitled to public funding, and now public funding isn't available for respondents at all, and of course that puts practitioners in a really difficult position where your client could be saying, well, I haven't done any of these things, but actually I can't afford to have representation. So looking at specific things that we should highlight for the respondent, and public funding issues, preparing the respondent for court. Also included here to ensure that we cover a wide area of matters acting for clients under an incapacity, and looking at the impact of domestic abuse, honour-based violence on other proceedings, other family proceedings that may be ongoing. So quite a lot of crossover in this chapter with wider family law issues, particularly what to do in the event of a breach of an order. Are you right there, David?
Yep, fine, all fine, yeah.
Having a small coughing fit, are you?
Sorry, I thought I was turned off there for a moment. Sorry about that.
No, that's all right. I thought it was me that was suffering from a cold today. Moving then on to part 4, which is private law children, and practitioners will be aware that the last version of the protocol really needs to be updated, because of course the President has issued lots of changes in that last 5 years that eventually resulted in the Child Arrangements Programme, which we incorporate in part 4. The Children and Families Act, obviously really very important, the importance of MIAMS now as opposed to a couple of years ago, and the role of CAFCAS and other experts, because of course Part 25 of the Family Procedure Rules was changed a couple of years ago, so that if you want to have experts in either private or public law proceedings, it has to be necessary. So a very slight change, but actually in practice that has really impacted, together with the LASPO Act changes, to make sure that people who are practicing private law children proceedings are as up to date as they need to be in looking at case management, the child arrangements programs. We don't look in this section at child support issues because that's in a separate chapter. We look here at for example, something that's very rare, child interveners in financial remedy proceedings. So touches on a very, very wide area. And I would imagine that many practitioners have some interaction with private law children proceedings. It's really useful to have something that's as up to date as this available to them. Part 5 then, children public law, which is of course a fairly niche area and becoming even more so because of the LASPO Act changes. A general overview, and I find this really helpful. I don't do public law proceedings myself, although have worked in practices where they do public law proceedings. Really helpful to have something like this, so that where you've got those crossover cases which are private law proceedings but actually there is a potential local authority about to step in, or where potentially legal aid could be made available in those circumstances, really useful to understand in a snapshot where we are currently with the duties of the local authority, the PLO, the public law outline, and any international issues in care proceedings. So whereas we've had a huge overhaul in private law children's proceedings, I'm aware that there has been a corresponding overhaul in care proceedings, but actually because I don't practice in that area, this is one of those chapters that I would cross-refer to as and when I need to, looking at things like pre-proceedings requirements, which when you're dealing with private law children work is really important because no proceedings have been issued, but where they're making, the local authority are making moves towards care proceedings, it's important to note what those would be and to be able to advise private law clients of those. And then, of course, grounds for the carer supervision order, care plans, which would be important, and that's really where a specialist would step in. But it's always useful for me to be able to advise my clients as to what they could expect if things tip over into care proceedings before I transfer the case over to somebody who's a specialist. And looking within those proceedings at adoption and placement orders, which doesn't often come up in my practice, but certainly it's useful to be able to refer to this, and special guardianship orders, for example, to be able to explain to the client what that's about. This chapter particularly, we've included a section here about transparency and openness. And again, I think it's something that family practitioners are really aware of, that the President has been driving changes to transparency, and that is ongoing, although the President's been a little bit quiet about transparency in the last few months, and certainly I don't think we've had a view from the President's chambers for about a year, I think.
Mena, can I just come in with a bit of sort of inside information, not inside information, but I was at the FLBA conference on Saturday, and the President was giving a keynote speech, as is his wont, and he was talking about the transparency issue. And I don't know whether you're aware that they've issued a pilot. They're doing a pilot in the Court of Protection about transparency and
Yes.
making things more open there. And he was sort of intimating that this is the pilot to see how it goes, to then progress transparency in the family courts as well. So that's the latest on the situation with transparency. That yes, he hasn't done a view, but he's going to be looking at that Court of Protection practice direction, seeing how it works in practice, and that might inform further moves on transparency. So that's just an aside there, but a bit of up-to-date information.
And it's really interesting because for a while, and I think around the time that the single family court was introduced, the President was really very keen. So about April, up to about April last year, was very keen on pushing ahead with transparency. And I think a couple of fairly well-known barristers started something called the Transparency Project, and lots of people very concerned about what the President was proposing. And since then, it has all gone a bit quiet. So it's interesting to hear. I didn't think it had disappeared, but it's been on the back burner for more than a year, really. So we've covered in the protocol what we can, and it's up to date. But of course, this is an area where there is likely to be quite substantial movement in the future, and it's something that I think Nicholas Mostyn, when dealing with the Gallagher divorce recently, was talking about transparency in his courtroom, and it's something that we hear from time to time, is that these issues of transparency and journalists being able to go into court and report on proceedings comes up, particularly with the famous divorces. But in care proceedings, the current practice directions that we have are really important, and have resulted in a fair number of judgments being reported on the Bailey website from circuit judges at local family courts, not just high court proceedings. And so those judgments are there really as a direct result of this move towards transparency, particularly in public law proceedings, and it does spill over into financial proceedings as well. At the end of this chapter, there's a huge amount of cross-referencing and sources of information. So for people who want more information, you're being referred to resolution, to cases, to Law Society practice notes. So as a resource, it compiles everything in one place. So if you aren't a specialist in this area, it's a really good read. It's easy to get to grips with the key issues and then cross-reference to other places if you need some more up-to-date information. Part 6 then is about abduction, and again this is a very niche area, only a couple of pages about abduction and the types of offence with the statutory remedies and the availability of mediation for international child abduction cases, with a cross-reference to the Reunite scheme. And then I think the chapter that personally I found really useful is part 7, which is about child support, written by my colleague at Shedden Family Law, who is Melanie Barnes, together with other resolution members of the Child Support Committee. And it's really, really comprehensive because, of course, in the last 5 years, we've had this change from the Child Support Agency to the Child Maintenance Service. We've got lots of different schemes that have run in the last 15 or 20 years, and it's really important to have a detailed overview of the scheme. So this chapter runs to 25 pages, and it looks at the current CMS scheme in detail and looks at the source of all the regulations. And I always say to people that child maintenance is really, really important. It's something that we get approached about a lot, but it's something that I could give you an overview of and look at the schemes, etc. But the new scheme, because it's so recently introduced, this gives you a very good up-to-date view of the new scheme, and it looks at departures and variations, for example, and that's also important because usually when clients come to me, they're looking at something that is not normal. They're looking at departures and variations, and the section of the child support chapter also covers appeals and complaints. So a really useful overview on the current child support scheme, so looking a little bit historically at the other schemes and more so looking at the new scheme. So I found that really useful. And then immediately thereafter, Part 8 looks at Schedule 1, and that follows on quite nicely from the child maintenance. Again, these types of proceedings are not run-of-the-mill proceedings for many family practitioners. I probably get 2 or 3 inquiries that would lead to anything under Schedule 1 of the Children Act per year, so it's not something that I do day in and day out. So it's really, really useful, again, to get an update, so not just an update on the Act, which of course we do look at. We look at jurisdiction of the Child Maintenance Service and the Court for Periodical Payment, so that crossover with the previous chapter makes sense, and looking at the different types of applications that can be made and the provision for housing and property orders and the other types of orders, so lump sum orders and periodical payments orders. And also what's really important is the current procedure, because of course the procedure for making these types of applications has changed, and if the final report of the Financial Remedies Working Group is implemented, may change again in the future, because I know that one of the recommendations that was made in the final report is for the different types of application forms that we have for financial remedy applications to be combined into one, and also for there to be a change to the Form E. The Form E1 is the form that we would use in terms of current procedure under proceedings, but it's likely, according to the Financial Remedies Working Group recommendations, that the E1 form will disappear and be combined together with the Form E, leaving just the Form E and what is now called the Form E2, and it's the Form E2 that's used for variation applications. So although we've got current procedure, we are aware of the potential for change in the very near future with regards to current procedure. And I think that's something that a lot of people overlook and potentially think the costs issues are the same in Schedule 1 proceedings as they are in financial remedy proceedings, so proceedings following the breakdown of a marriage or civil partnership, when they're not. In fact, the costs rules are very different for Schedule 1 proceedings. So it's really useful to have that section on costs here, so that you can have a look at the costs rules and the fact that without prejudice saves to costs letters or quarterback letters still exist in Schedule 1 proceedings, which isn't necessarily that well known, and looking also at cross-referencing international elements into the Schedule 1 application. So where you've got an international element, it's useful to have a look at the guidance given in this chapter. So quite a lot of information contained in Part 7 and Part 8 that cross over from each other. Then we've got what people, I guess, do most of is divorce dissolution. If this isn't an area that you specialise in, so let's say child abduction is your area and you occasionally do a divorce, and again this is a useful section to dip into because of course there's been quite a lot of change in relation to divorce. This section looks at the interaction between religious divorce issues with the English divorce procedure, and as we have an increasingly multicultural society, we are often dealing with those types of things and looking at the divorce procedure following the creation of the family court and divorce centres. And of course, since the last protocol was written, we have had the introduction of the Same-Sex Marriage Act and looking at the dissolution, divorce of civil partnerships and divorce in same-sex marriage. So quite a lot of information in this section. Again, as we've tried to do in the rest of the protocol, bringing everything up to date and looking at not just up to date, but looking at best practice. And looking at, in this section, of course, defended proceedings, but there aren't often defended proceedings in divorce or dissolution proceedings, and touching upon judicial separation and nullity, which are still valid and are still used. I think there are between 500 to 700 judicial separation nullity proceedings issued each year within England and Wales, so it's worth knowing something about those types of proceedings. And at the end of that chapter, crucially, information about applying for decree absolute and the consideration that practitioners need to look into when they are looking at that type of application, which I think is pretty important. I think we've got a question that has come through, David, so it might be a good way to
leave that one to the end. I think it's a question to leave to the end. I just wanted to put you in touch with it so that you could have a think about it, but I think we'll leave it to the end. Okay.
Okay, we'll address that one at the end then.
Yeah.
So we've got the, so that's part 9, and then that of course leads on to what follows really, which would be the financial remedy procedure in part 10. And again, a fairly concise, useful chapter, about a dozen pages, looking at different types of things. We've already looked at non-court dispute resolution in respect of all proceedings, and of course that does still apply to financial remedy applications, looking at the overriding objective, and of course voluntary disclosure. So voluntary disclosure and the pre-application procedure, and it's really important that practitioners are aware that what used to be the Law Society's pre-action application to disclose financial information was combined into the new family procedure rules when they were introduced in April 2011. And so Practice Direction 9A now encompasses a pre-action protocol which is slightly different to the old, so the last edition pre-action protocol. So bringing all of that up to date, really helpful that that was done by the Family Procedure Rules Committee at that time, and to try and ensure that practitioners are aware of not just the non-court dispute resolution options, but of this pre-action procedure in terms of voluntarily exchanging financial information rather than getting your MIAM and rushing off to court to issue a Form A. Looking, of course, at interim orders specifically and a new application that has been available since the last BOE Act changes, Section 22ZA application for legal costs to be paid to fund the current proceedings, and that is looked at in this. And looking in detail at the duty of disclosure, again, the book was published before we got this Supreme Court decision in Gohill and Sharland, which you covered by webinar, I think a day after the judgment was handed down, David. But looking at disclosure and the importance of proper disclosure and the consequences of failure to disclose. And looking very importantly at self-help, particularly following Immerman and Schenges and Immerman, which now the Court of Appeal decided in 2010. So just on the cusp when the last version of the protocol was introduced. Expert evidence, of course, I mentioned earlier that Part 25 of the Family Procedure Rules was changed in the last couple of years, and that's impacted on the instruction of experts in financial proceedings as well as in private and public children proceedings. And looking at the process and the procedure, which isn't new, but it's worthwhile updating practitioners on that, so that is also enclosed herein. And looking at consent orders, and of course we've got the new precedents that were drafted by Nicholas Mostyn and others that are available on the judiciary website. And of course you couldn't have a chapter on financial remedies without looking at the costs that are currently applicable, and of course we're looking here at civil partnerships. The financial remedies section is really important. It gives you a really good overview, and as with all the other chapters, cross-references to other useful resources that the practitioner can have a look at if needs be. The next chapter then, part 11, looks at cohabitation, and of course this is an area of increasing complexity and increasing use. One of the statistics at the beginning of the chapter says that position is becoming untenable. Increasing numbers of the population live together without marrying, and in the recent census, we're looking at a rise in over 40s from 31% in 2001 to 41%. So we've had a 10% increase in cohabitation in 10 years. So this is one of those areas that practitioners need to keep an eye on, need to be constantly updated, and of course because of the issues surrounding cohabitation remains incredibly complicated. So for those practitioners who don't have many cohabitation cases and concentrate maybe on married or civil partnered relationships breaking down, having a cohabitation case can be slightly concerning, most of all because we're using the CPR and not the FPL that family practitioners are most comfortable with. And it's worth mentioning here that of course you're looking at using non-court dispute resolution processes that we looked at in part 2. You're also looking at using arbitration as part of those processes. So even though these are CPR processes, arbitration is still available, and it comes under the finances umbrella. The advice that you should give to parties following a breakdown is set out clearly here, and looking at what to do prior to issuing. And of course the protocols that are attached in the CPR have more weight than potentially the protocols that we've got in the FPR, and the consequences of breach are much more important to consider. So prior to issuing, looking at what needs to be done and looking at the NCDR processes, and crossing over in this section to looking at the claims that can be made by cohabitants under the Inheritance Provision for Family Independence Act, because it may be that you're being approached in a family matter where someone has come to see you because their partner has died and they weren't married, and assets are in the partner's name that need to be taken into account in circumstances where perhaps there isn't a will or a will can't be found. And it's an important section and of increasing importance to family practitioners. We can't all be specialists in every area, and I think the beauty of the protocol is that we could get to grips pretty quickly with a new area, because the book gives us 5 or 10 pages of really important information, and then you can look into it further. But if you had a new client coming in and you just wanted to get an overview, you could have a read of the chapter that you think you need to have a look at in 15 or 20 minutes, and it would give you a really good place to start that first meeting. Part 12 is about forced marriage and female genital mutilation, and these are areas that have been introduced since the last protocol was introduced. Forced Marriage Act was introduced in 2008, so I think it would caught the tail end of the last book. But there have been new offences introduced, and it's really important that practitioners who are looking at forced marriages look at it as a cross-reference to the domestic abuse and honour-based violence chapter, because they run together really. Looking at forced marriage and domestic abuse, and the screening questions that are set out in that chapter do cross over here. We look at the scope of the Forced Marriage Act and the new offences that were introduced, and of course there's a definition here. Practitioners might think that it would be obvious what a forced marriage is, but actually there are lots of different types of forced marriage, and it's really useful to read the definitions section here, and there are some useful questions that are designed for practitioners to ask clients if there is a suspicion or there's a potential that there is a forced marriage that has taken place or is about to take place, so that you can ascertain what to do in those situations. So there's lots of very practical information here. There is information about forced marriage protection orders, the FMPOs, because they became a criminal offence in 2014. So since this was introduced, there has been some movement and change to Forced Marriage Act. And I believe a couple of months ago, the first person was prosecuted for forced marriage, and that certainly was in the headlines. And so this is again an area where practitioners are not likely to have had a huge amount of experience, and this is, you know, a few pages that you can have a look at to see what the law is, who can apply for a forced marriage protection order, what funding is available, what forms you need to use, and other practical considerations that a solicitor would need to take into account if they are thinking about bringing this kind of application. So areas, female genital mutilation, for example, areas that parties are just not going to have had, that solicitors are just not going to have had a huge amount of exposure to. Part 13 also looks at a growth area, or an area that is, there are a few niche practices that deal with alternative pathways to parenthood, but of course this can come up in an average case where clients come to see you about a divorce, and then it transpires that the children of the family were not conceived in the usual way, and that they have been conceived differently. And of course, domestic adoption is pretty straightforward, but there is a section here about adoption and fostering within this jurisdiction. And then looking at step-parent adoptions and inquiries about step-parent adoptions where I practice have started to increase, and again, as people decide that divorce is a better option and remarriage or new relationships and step-parents children becomes more normal, it's something that practitioners need to be able to look into. We also look in this section at inter-country adoption, so where people are going overseas to India or Russia or China, and looking at adopting, what factors a solicitor needs to take into account when faced with somebody who's suddenly said out of the blue, this is what we did. And surrogacy, of course, domestic surrogacy becoming more and more of a commonplace thing for families these days, and differentiating between domestic surrogacy and also a section in this chapter about international surrogacy, as they are two different things, and the factors that parents need to have taken into account are different in those situations. And a short part at the end in dealing with other types of parentage using assisted reproduction, and again, these are cases that recently the President has been dealing with. They're an area of change, and we've kept this up to date to about September of 2015, but I think we just missed the new cases that the President dealt with recently, so I don't think those are included here. Right at the end of the after part 13, we've got a few appendices with useful guidance and online resources, and as I said at the beginning, with the cross-referencing, if you get the online version of the protocol, then you can click the links and go through to whichever cross-referencing chapters you need to go to, and Appendix B contains useful contacts and websites. So as you had previously, you know, the addresses of different organisations. Of course, Resolution is there with the Resolution website. So all in all, this version of the protocol brings the family practitioner right up to date and ensures that anyone who is, let's say, dabbling in family law has a resource that they could use to ensure that they are dealing with things in the most effective way and the most up-to-date way given by both Resolution and the Law Society. So, David, now's probably a good time for questions.
Right. Well, I think I forwarded one on to you earlier, the one we mentioned earlier, which was a sort of slightly fundamental question about the nature of the protocol, which is somebody saying they're tired with dealing with aggressive family lawyers and do not seem to take any notice of the Resolution Code. Why would such people take any notice of this? Which I mean, my view is the answer is it's a different sort of document. But what's your feeling of that?
I think it's interesting because I am a Resolution member and I'm a Resolution accredited specialist, but I'm also on the Law Society Family Law Committee, so I've got my feet in both camps really. I think that sometimes there can be a resistance against Resolution because of the Code of Conduct, and lots of practitioners don't sign up to Resolution for membership because they don't want to be bound by the Code of Conduct, which is one of the conditions of membership. But actually the difference between the Law Society's Family Law Protocol and the Resolution Code of Conduct is that anyone can buy the protocol and say, right, I practice family law, I don't necessarily want to tie myself or my clients into the Code of Conduct with Resolution, but actually I could look at this book and say, this is the best practice, let me make myself aware of it, and then I can choose whether it's relevant in those circumstances to go forward. And because this is endorsed by the Law Society and it's not mandatory, so if you were a Law Society family specialist and you've taken the advanced exams, then yes, you would need to know about the protocol. But actually, it's just useful. It's a useful book for somebody, and I know lots of practitioners out there on the high street sometimes dabble in family work, and they don't necessarily know what the current protocol is. You know, if they've been doing it for 30 years, they might not be keeping themselves up to date. I also wonder whether it's true that people don't pay attention to the Resolution Code of Conduct. I certainly looked at the last magazine that Resolution sent out and saw that there was a very interesting section where they are asking for people who've got examples of bad practice to write to them, not as a complaint but as a guidance, and they're saying, well, send us something that you think is bad practice and we'll look at it as a reflective learning exercise, so to speak. Let's look at it and see how you could have done things differently. I've never had cause to complain about another resolution practitioner to Resolution, so I don't know whether or not it's a toothless dog, which I think is what's being suggested.
Actually, on that point, I was at the there was a question session at Resolution National Conference this year, which was, I don't know whether you were there, Mena, but somebody raised that very same point and saying, why aren't there sanctions for people who do breach the Resolution Code of Conduct? So I think anecdotally, and maybe it never gets fully reported, there are people who have issues with with the other side not abiding by the code, but as you say, maybe it's not reported, or but I think the answer is, to the question though, is this is a different document. It's suggested best practice, isn't it, rather than this is how you should act.
Yeah, it's not only suggested best practice, and I think that people who maybe haven't got a copy of this book or haven't had it for a few years, because I think from my recollection the first version of the Law Society protocol was sent out to family practitioners, and then you had to buy the second version. You've got to buy this version, but the main protocol, as I said, is freely available on the website. And I think that what people may think is that this is a different version of the Resolution Code of Conduct, and it's not. This is actually quite a practical book, and I've been trying to get across that it's not just, oh, you know, everyone should behave in the same way. This book, apart from part 2, which is about non-court dispute resolution, really takes you through niche areas and says, right, this is what you need to do. This is where you can issue applications for forced marriage protection orders. These are the courts that you can go to. These are the forms that you can use if you want a forced marriage protection order, which is something that people tend not to do. And so it's not just a sanctimonious, you must do this in this way. It is actually quite a useful, practical book that says, if there are areas that you don't deal with, for me that would be public law children, then this is a useful kind of summary of things that are happening, so that if you've got a client that comes in, you can have a sensible conversation about that area, and then, you know, from my part, refer them on to someone else, because they would be entitled to legal aid if that was the case. So it's just making sure that people have the relevant information about all areas of family law in one place, in a book that is quite short, but all the chapters are, you know, easily organised and easy to read.
As a sort of follow-on, here's a slightly speculative question. Could there be cost implications in cases where the protocol or the Resolution Code of Practice has not been followed?
Potentially, because it's always been the case. Part 28 of the Family Procedure Rules deals with costs orders, and the court, when looking at making costs orders, can look at pre-application conduct, and so the court could look at the pre-action protocol, the family law protocol, resolutions, code of conduct, all of which say you shouldn't just rush off and issue applications, that you should be looking at using non-court dispute resolution processes, etc. And the court could say, well, you didn't look at these, you rushed into proceedings, and as a result we're making costs orders. And recently, in a case, costs orders were made more on, it was an appeal case where Nicholas Mostyn had said, when giving permission to appeal, yes, you know, I'm giving you permission to appeal, but you should really look at mediation. The parties, one of the parties tried and the other one didn't try as hard, and ultimately costs orders were made against the party that didn't try as hard. So I think that it really depends on how judges are going to interpret Part 28.
My
and
feeling,
whether their interpretation will lead to cost orders.
my feeling is they're going to become increasingly, well, not harsh, but they're going to try and be more careful with costs, aren't they? Is just a feeling I've got. I've got nothing else to back that up other than what I hear from people.
Yeah, well, I mean, Nicholas Mostyn's made it very well known in his recent judgments, J&J from last year, particularly, that he doesn't like disproportionate costs in financial proceedings, and he's going to do everything he can to try and control those costs. And I think at the At a Glance conference, David, there were questions from the audience about fixed costs, and the President's quite keen on unbundling and fixing costs in financial proceedings. And Nicholas Mostyn was saying that he was very keen and that family practitioners should be able to do it, and he wants them to start doing it as soon as possible.
Yeah. Okay, one very practical question from me. The online edition you mentioned of the book, is that going to be updated in the interim? Just so I know, just might be useful for others to know out there. If say new cases come in, or is that a static thing? I know the difficulties of trying to update it, so don't feel sorry about it.
I don't think I know the answer to that question. I certainly think that at the committee we saw the benefits of being able to update it if necessary, but I'm not certain how frequently it will be updated, because of course we've only just got this book published and online, so we haven't looked at updating, but it's certainly a question that I will pose to the committee next week when we have our meeting.
Yeah, just be useful to know, I think, for everybody out there. But
yes.
Yeah. Well, I don't think we've got any other questions, unless there's anybody out there who'd like to pose any more questions. I'll wrap this up just in time. Actually, we've got another question. We have got one more question. Just as I think it's not specifically to do with the protocol, but what is your view on unbundling? Recent Law Society Gazette article suggests we should be careful, particularly on financials. I think that's referring to the Minkin versus Landsberg case that came through last week. About
that's right.
Bundled services and unbundled services.
I think that practitioners very easily get carried away with offering unbundled services without making it very clear that that's what they're offering, particularly in the case of that the case that was reported last week, where someone comes along after mediation and says, "Oh, can you just draw off this consent order?" and you say, "Yes, that's fine." You historically might not think that that's unbundled services, but it is. And I think what practitioners don't do is they don't read the Law Society's practice note on unbundled services, because actually unbundled services are pretty high risk. And if you are going to undertake unbundled services, A, you should have read the practice note, and B, you should implement safety checks within the firm to ensure that you realise and the client realises exactly what they're signing themselves in for. I have to say, it's not my favourite way of working, but I think it's inevitable that with LASPO Act's changes, that the clients are only going to be addressing us for certain types of thing, because that's all they can afford to do, and we're just going to have to be adaptable.
Right, okay, yep, I think that's no more questions there at the moment. We're just about bang on 2 o'clock, so I would just like to, first of all, thank Mena for that excellent run-through of the new protocol and where it stands within the family lawyers' armoury. I'll just also like to let you know that our next webinar is scheduled, we've got a Christmas break coming up now. Next webinar is scheduled for Friday the 29th of January. That's with Piers Presdy QC, who will round up the year's developments in private children law. So he'll be looking back on 2015 and rounding up all the key issues. We'll send sign-up details on the Family Law Hub daily in the next week, hopefully. If you don't get the daily email, it is free, and it's the best way to keep up with when our next webinars are going to come up. And you can sign up directly from there, or you can visit the site next week, and we should have a link on it from there. If you want to sign up to the email, just send me an email at david@classlegal.com, and I'll make sure you're added to the list. There is one other, we might have another webinar in between times. We're still trying to work it out, which might be Divorce Centre's question and answers with the team from Bury St Edmunds, but I don't know whether I'm allowed to say that, Mena, am I? Or we're hoping to arrange one, aren't we?
You are allowed to say it. We just can't get a date together with the people at Bury. So we're just trying to get the date together. And once we've got the date together, they're happy to participate and let everybody know what's going on at Bury, which everybody I think is interested in.
So that may or may not happen before Christmas. So, but we will let you know as soon as we've got a date, and give you a link to register for that one. Obviously, we've got this is going to be recorded. This has been recorded. I will send a link round with the link to the hub page where the webinar will be hosted. You will need to be a member of the hub to access that. But if you would like a free trial for the hub for the 14 days, similarly, send me an email at david@classlegal.com, and I'll get our team to get in touch with you and set you up for a free trial so you can listen in that way. So that's it. Thanks again to Mena. Thanks for your contributions.
Thanks,
and
David.
thank you for listening. And hopefully we might be speaking to you again before the new year. If not, Friday the 29th of January.